Hello, everyone, and thank you so much for joining us for this presentation on domestic asset protection trusts. Before we get started, I just wanted to share a couple of quick housekeeping notes. The slides for this presentation are available to download in the resources section of your Zoom event portal. And if you have any questions during the presentation, please feel free to just enter them into the chat. We're going to do our best throughout the program to get to them. Today's speaker is Abigail O'Connor, who is the Chief Legal Officer at Peak Trust Company. Abby is a longtime estate planning attorney and brings a valuable perspective from both the planning side as well as now from the trustee administration side, where she works closely with trusts administered both in Alaska and Nevada here at Peak Trust Company. Peak Trust Company serves as a corporate trustee in both Alaska and Nevada, which of course are two leading trust jurisdictions. And our team regularly works alongside estate planning attorneys and financial advisors and families across the country to help administer sophisticated trust structures. A little disclaimer, of course, this program is intended for educational purposes only and should not be considered legal or tax advice. And with that, I'm pleased to introduce Abby O'Connor.
Well, thank you very much for that wonderful introduction. My name is Abigail O'Connor. I am Chief Legal Officer of Peak Trust Company. I'm a longtime estate planning lawyer. This is all I've done as an attorney, and I've been in Alaska for the last 11 years. And when I moved to Alaska, I was unaware that Alaska was the first domestic asset protection trust jurisdiction in the U.S. And in any event, learned a lot about it. And I joined Peak Trust Company about 18 months ago. And Peak Trust, we are a corporate trustee in Alaska and Nevada. We have many domestic asset protection trusts under our charge. And so most of my experience comes from the trustee administration side. And because of that, I've reviewed many domestic asset protection trusts and have seen a lot of variation. So please keep this somewhat conversational. If you have questions, put them in the chat. I will try to answer them as soon as I can. But this is really for you. And when we talked about what I would talk about, as I was trying to think, okay, well, if I was an estate planning attorney and interested in getting into this space, what would I want to know? And I've got a laundry list of a disclaimer here, but the short story here is that I'm assuming you're all estate planning lawyers. And if you do have a client for whom you are considering a domestic asset protection trust, you will do your homework, facts, circumstances, applicable law, and then make your own decision as to whether or not it's a good idea. So before we get into it, asset protection is a very wide study. And there are many types of asset protection vehicles as estate planning attorneys that we can use. All we are focused on today is the Domestic Asset Protection Trust, which is an irrevocable U.S. trust, making it domestic, for which the grantor is a permissible beneficiary. Does not have to be the only beneficiary, but if the grantor or settlor is a beneficiary and it's an irrevocable trust, then it is a Domestic Asset Protection Trust. I'm just going to refer to it as a DAPT because that's quicker. Why do people create DAPTs? There are three primary motivations. Well, the obvious one is to protect the assets from creditors and from future creditors. And this is, as the name implies, a domestic asset protection trust, and definitely a motivation for certain individuals. But if you ask Jonathan Blotmacher, who is the nationally known attorney who really brought DAPTs to the US, that wasn't his motivation for getting legislation passed in Alaska. His motivation was estate tax planning, because it was very difficult to get clients to part with their assets to use their exemption amount. And so the Domestic Asset Protection Trust came in as a way to, if you structure it a certain way, where the assets should be excluded from your gross estate and you should be able to use your exemption, but the grantor can still potentially benefit from the assets. So that became really his motivation, and it was estate tax planning. It was not necessarily asset protection planning. And then in recent years, I've been hearing more attorneys talk about using DAPTs as an alternative to prenuptial agreements. I'm not sure they're as good, would prefer to have a good prenuptial agreement, but there are many circumstances when the future spouse is not excited to talk about a prenuptial agreement, and the moneyed spouse still wants to do some protection for his or her assets. And if done correctly with proper planning and implementation, then it may provide some benefit and some protection upon divorce, not in all jurisdictions, but in some jurisdictions. I don't know that I would rely on it solely for premarital planning. I would be very excited about combining it with a good prenup. I think that would be a good strategy, but they are a potential alternative to prenups, and so I'm mentioning it here. The DAPT drafting will depend on state law, but there are some common key structural elements to adapt. As we discussed, it needs to be irrevocable. The grantor is a beneficiary. That's what makes adapt. There can be other beneficiaries, and frequently there are other beneficiaries. The ones I most commonly see is the grantor, spouse, and descendants. It's created in a U.S. jurisdiction that has a statute that allows DAPTs. And what I mean by that, we can talk more about it, but I mean a state that has a statute that essentially says the spendthrift provision will be effective even if the grantor is a beneficiary. And it has to have a spendthrift provision. If you're not familiar with that term, it's a provision in the trust against the involuntary alienation of the beneficiary's rights. And I've seen them called protection of interest provisions. Most of the time I see it called a spendthrift provision. And then the grantor can often retain some control over investments, but not distributions. That's a common key element. There are now over 20 states that have statutes that authorize domestic asset protection trusts. Alaska was the first, starting with the 1997 Alaska Trust Act, and Delaware soon followed, and now we have a number of states. I would say the more popular ones are Alaska, Nevada, South Dakota, Tennessee, Delaware, New Hampshire, and those are the ones that I most commonly see and hear about, but there are others that have state statutes. There's a wonderful comparison out there maintained by my colleague and ACTEC fellow Dave Shaftel. And if you write down shaftellaw.com, SHAFTELLAW.com, on Dave's website, he maintains a state comparison of DAPT statutes and DAPT laws and even cases. And it is quite comprehensive. He maintains it for the American College of Trust and Estate Counsel, ACTEC, but he publishes it on his website, and I use it frequently as a guide. And we're going to get into this a lot more about choosing the right jurisdiction or choosing an appropriate jurisdiction and creating a nexus to that jurisdiction, because it's really important in the design and planning of a trust. But before we get into that, I want to talk a little bit about which clients. I can tell you both on the planning side and on the trust administration side, the wrong client will destroy the DAPT. And it's not intentional. It's just knowing ahead of time when you get a phone call from a potential client or even an existing client, hey, I read about this asset protection trust. I want one. Really, you need to vet the client and the purpose. And there's a lot of vetting that needs to be done before you even get to drafting. And so we start with the universe of who is in general for a domestic asset protection trust. Some obvious choices: high-risk professionals, surgeons, doctors, some lawyers, business owners, definitely a good candidates. Wealthy individuals, I mentioned that this is now being looked at as a prenuptial planning or premarital planning. Other high-profile individuals. So this is the universe. We start from there. And then timing is key with setting up a domestic asset protection trust. And you need somebody who is in a good period of time, meaning they're not in litigation or administrative proceedings. They are not expecting any. They are not expecting divorce. They are not expecting bankruptcy. It's not foreseeable. You don't want somebody who is doing this because they have a current creditor problem or a very foreseeable creditor problem. We'll see later, there's a recent case where quote unquote divorce was imminent when the husband created these DAPTs and it didn't go well for him. Timing is very important. And unfortunately, a lot of the questions that come in, especially people who are researching on the internet, are doing it because they have an issue. And so timing is key, and asking a lot of questions is very important. And then someone who still has a lot of income and cash flow to pay assets or pay expenses after creating a DAPT. So the ideal situation is this client who has no litigation pending, no bankruptcy or divorce even remotely on the horizon. Everything is good, calm waters, and also someone who has assets that he or she does not need, assets that can be siphoned off into a DAPT and really not touched and just looked at as a nest egg or an emergency fund. Appreciating assets are great candidates for this. I put in commercial real estate because I think that's a great asset for a DAPT, or can be a great asset for a DAPT. Things that I don't like in DAPTs, cash, that's not, because usually people need their cash. They want to use their cash. Personal residences. This is one I am not a fan of, putting a personal residence in a DAPT. And why not? One of the key elements, not a drafting element, but a implementation and design element, there cannot be an implied agreement between the trustee and the grantor that the grantor can use the assets. Well, if the grantor puts his personal residence in the trust and still lives there, how can you not conclude that there was an implied understanding that he could stay in the house? So I don't like personal residences. That's just my opinion. Other attorneys may disagree with me. Also, the operating business that supports the family, perhaps a minority interest, maybe that can go into a DAPT. But if it were me, I would not want to put a majority interest or even a large interest of the family business into a DAPT. Because again, what's the implied? Is there an implied agreement that the grantor can still access that income? It's a really nasty surprise to grantors when they put their family business into a trust and then they're told that they can't have the income from it. So this is the ideal versus not ideal. Also, just in terms of working with clients, you need the right client, someone who is sophisticated, is not going to try to continue to control, is going to understand and appreciate the fact that these assets are going into this trust and he or she is losing control over them and handing control over to somebody else. They're not looking for a quick fix. They are open to continuing to work with counsel. On the trustee side, one of our challenges is when we have grantors of DAPTs that have long either fired their attorney or no longer work with their attorney, and they come to us with questions, and the best we can do is say, you need counsel. That's a legal question. You need to contact counsel. So just think about that when you're getting a call. It's much better to say no than not sure. Also somebody who is overall doing an estate plan. Adapt is one piece of the estate plan, but it shouldn't be done in isolation. And I'm going to repeat it again because it's really important. There cannot be an implied agreement between the trustee and the grantor as to the use of the assets. In Alaska, we call it the wink and the nod agreement. You can't, I can't create a trust and name Peak Trust as the trustee, and the trust says that Peak Trust has full discretion. But Peak Trust knows that I need those assets. And so, I know they're going to let me live in the house that's owned by the trust. And I know that they're going to make the distributions that I ask for every year. That's a bad fact. And we don't want bad facts. So I will repeat this again and again because it's very important. Okay. So that's, do you have the right client? Is it a good fit? Conflicts of laws. This issue is becoming really a hot topic because our trusts that we're creating today are very different than 20, 30 years ago. 20, 30 years ago, a trust was created in state X, the trustee was in state X, the grantor and the benefit, everybody was in the same place. Nowadays, we may not even have two things in the same place. So this is just an example. But we might have a New York, and we see this all the time. We might have a New York grantor who creates a trust in Alaska, and then the trust has to move to Nevada. The governing law can't be changed. So we have an Alaska governing law, we have Nevada situs, but his children who are the beneficiaries, and he lives in New York and his children live in California and Florida. The trust owns commercial real estate in Indiana. And then Peak Trust in Nevada is one of the trustees. And then the grantor has a friend in New York appointed as an investment trustee. Oh, we have many touches. Many states touch this trust. And if there's an action filed, where is it filed? We would love for it to be filed in Nevada because that's where it should be filed. But creditors seldom take the path that the trust wants to do in terms of jurisdiction. So the issue comes in is where is an action filed, who has jurisdiction, and which law applies. And this goes back into public policy issues, and not all states support domestic asset protection trusts. And this is a big deal because if you have a domestic asset protection trust that is the subject of litigation in a state that does not support asset protection trusts, they are less likely to uphold the sanctity of the trust. The public policy issues go back as far back as 1571 with the Statute of Elizabeth in England, which formalized protections for creditors and prohibitions on fraudulent transfers, including to a trust. And this was the law of the land until the Cook Islands came in the late 80s and created the offshore trusts, domestic or offshore asset protection trusts. And then in the late 90s, Alaska came in and said, hey, we'd like to have these trusts here. And so created the Domestic Asset Protection Trust statute in Alaska, and then all these other states joined in. But we still have states that have not enacted Domestic Asset Protection Trust legislation statutes, and for which they are against public policy. They are still back to Statute of Elizabeth. They're against public policy. If you create an irrevocable trust and the settler's a beneficiary, the assets are not protected against that settler's creditors. And this is still an issue. So we have that, and then layer that on top of the Uniform Voidable Transactions Act, which has been enacted in most states, either the 2014 version or prior version, which goes into voidable transfers. When is a transfer voidable in terms of the intent to defraud creditors? You should be familiar with that if you practice in this space. And then we also have upcoming, hopefully this summer, will be the enactment of the Uniform Law Commission has taken up the conflicts of laws issue and created this new act where they try to address and mitigate this modern trust concern where you have all these jurisdictions and which law applies and which jurisdiction applies. And it's, if you have a chance to read it, it's available online. I would suggest that you do. I'm going to breeze through this here a little bit because we're a little tight on time. But my tips for you is, if you're creating a DAPT, I go through and identify all of the states that will be touched by the trust or that will touch the trust, like that first illustration, and determine which ones support DAPTs and which ones don't, and try to mitigate those circumstances. So if you can reduce the nexus with the states that where it's against public policy, try to reduce that. Will it work or not? Don't know. But you can at least make an effort to reduce those touches. And also just helping the clients be aware of the potential issues that could come up, because they do. So there are a few tax considerations to think about when you're looking at a DAPT. The first is, will the trust be structured as a completed gift trust or an incomplete gift trust. And how to create them is really beyond the scope, but a completed gift trust, we do have two PLRs to mention here. One is that says that the DAPT is a completed gift for gift tax purposes, even though the grantor is a permissible beneficiary, but the grantor cannot have any power over the disposition, and it's a spendthrift trust. Go ahead and read the PLR, it's worth reading. And then another PLR that says the assets are excluded from the gross estate at death. Keep in mind, these are PLRs, they are not precedent. And that's very important. They are not precedent. It's good to know what they are and know what they say and try to stay within those facts, but they are not precedent. And so if you going back to the completed gift, the strategy there with the completed gift is that then you're using exemption and you're hopefully excluding the assets from the gross estate at death. So this is more of an estate tax planning. If estate tax planning is not one of the motivations, then an incomplete gift trust may work better. And that's for one where the grantor retains control over the assets. And typically what we will see there is that the grantor retains a veto power over distributions combined with a testamentary power of appointment. Then there's no gift upon creation. But one little trap here is that if the grantor creates an incomplete gift trust where the grantor and let's just say the children are beneficiaries, as soon as a distribution is made to the child, well, now that portion, that is a completed gift. And this isn't something that I don't know that people always think this part through, because if it's large enough, then there needs to be a gift tax return. So just think about that. And then with an incomplete gift trust, the assets remaining in the trust are included in the gross estate at death. So incomplete gift versus complete gift, that's the first decision. The second decision to make is whether or not the trust will be a grantor trust or not. By default, if the grantor is a permissible beneficiary or even the grantor's spouse, then the trust is a grantor trust and income will be taxed to the grantor. The only hard part about this is the reimbursement of the grantor for income tax portion. And we'll talk about that a couple of times. In my experience, clients are understanding and fine with the concept of a grantor trust because it's a way to essentially make tax-free gifts to the trust by paying the tax that would otherwise be payable by the trust. However, they don't like it in two circumstances. One is if there's a large income generating event where the trust ends up with a pretty large tax bill, which means the grantor ends up with a very large tax bill. And the phone call to the lawyer is, okay, that's fine. Just have the trust pay the tax. Sorry, no can do. That is your bill to pay. It usually is met with some unpleasantness from the client, understandably. And then the other issue that I've seen is when a client retires and is no longer has the cash flow, generally they don't want to pay the tax anymore. Now, I will say most of the older trusts that I see, the older DAPTs, have an outright prohibition on reimbursing the grantor for income tax. But if you review the tax law, you don't have to prohibit it. An independent trustee can have the discretion to reimburse the grantor for income tax. And then there are now a number of states, and I have them here, that if the trust does not prohibit income tax reimbursement to the grantor, then under state law, the trustee can reimburse the grantor. But even if the trustee has the ability to reimburse the grantor for income tax, doing so on a regular basis could prove problematic. It could be a bad fact pattern that could end up causing estate tax inclusion and undermining the trust. So something to keep in mind if you're doing a grantor trust, and again, most DAPs are just something for which to be aware. There are some DAPs that are created as non-grantor trusts. In order to do that, any of the grantor trust triggers have to be done with the approval or consent of an adverse party. So I've highlighted that here. Take a look. The majority of the DAPs that we see are grantor trusts, but we do have a few attorneys who like to make them non-grantor trusts, and just be mindful as to how that's done. Okay. I'm going to move on so that we get, I think we've only done two things so far. So drafting the DAPT. Okay, you have done the client vetting, you've looked at the design, and now you're actually drafting it. So these common provisions that we see and that we like to see, first of all, distributions should be at the discretion of an independent trustee. Independent meaning related and not subordinate. So yes. And spendthrift provisions, you want to make sure those are in there. And we like to see, and I think the general consensus is there should be a prohibition on the grantor being a trustee. And we often see that extending to spouses as well. He could be uber conservative and not have anybody related or subordinate be a trustee. All trusts, hopefully, have language about governing law and principal place of jurisdiction. That's not just a DAPT thing, that's just a drafting thing. And then another thing that should be addressed at the drafting stage is the definition of the spouse. And we'll get into that more later when we talk about divorce. Be careful with the grantor's retained involvement. So under state statute, the grantor may, it depends on the state, but in Alaska, the grantor can be the investment trustee. The grantor, it can be a directed trust with the grantor as the investment advisor. That's all allowed in state statute. But recently, at least the cases that I've been reading, those factors have been influential to the court in either unraveling the trust or having a result that's negative to the settlor. Although the statute allow it, just be aware that it could influence the court in a negative way in the future, at least if you're reading recent case law. The grantor cannot have any mandatory rights to distributions or reimbursement for income tax. Removal and appointment of trustees, the more separation the better. I think my preference is for that role to be satisfied by a trust protector, to have a trust protector be the one to remove and appoint trustees. The grantor may be able to appoint the trust protector, but it just gives a level of separation. And as I've mentioned before, no implied agreement between the trustee and the grantor. So that's really critical. And then with drafting any irrevocable trust, DAPTs are included. It's really helpful to have flexibility built in, either to have the principal place of jurisdiction be in a state that allows decanting, or you have internal decanting provisions, but that's not DAPT specific. That's just irrevocable trust specific. But one DAPT really key takeaway, if you're drafting it, know what state is going to govern and follow that state DAPT statute to the letter. We'll talk about a recent case later in this presentation where by all rights, there were some issues, but that trust followed state law and the court upheld the trust. So we talked about drafting it. Now let's talk about actually setting it up. So the jurisdiction, we've talked about conflict of laws. We've talked about that there are about 20 plus states that allow for self-settled trusts. Choose the jurisdiction wisely. If your client lives in a DAPT jurisdiction, that could be a good starting point. And it may not be the only factor, because remember, there's other factors to choose different states. There's rule against perpetuities. There's state income tax, all sorts of things. Of course, if it's a grantor trust, state income tax, it's going to be taxed to wherever the grantor lives. But if it's a non-grantor trust, maybe not. So choose the jurisdiction wisely, and then create nexus. So you'll need a trustee in that jurisdiction in order to have that attachment. In Alaska, you have to have a qualified trustee in Alaska, which for an individual means somebody who resides here and is domiciled here. And if it's a corporate trustee, Alaska requires that the corporate trustee have its principal place of business in Alaska. So it cannot just be a corporate trustee that's in a different state that's authorized to be a trustee in Alaska. They have to have a principal place of business in Alaska. And so that's the trustee selection. And then what about assets? So again, where are the assets? And Alaska requires that at least some assets be on deposit in Alaska. So at Peak, we like to have some cash that we're holding. There's no requirement as to how much. There's been, to my knowledge, no court has said how many of the assets. One of the ways that we like to see more nexus created is taking the assets that would otherwise be in the trust, put them into an Alaska LLC, and then the trust holds the Alaska trust holds the Alaska LLC. So we'll have an Alaska trust with cash held in an Alaska bank and an LLC in Alaska. The LLC will own assets all over the place. And is that enough nexus? I don't know. We haven't tested that yet, but that the more the better. The more nexus, the better. And then mitigate the arguments against other jurisdictions. I know one attorney who will only do directed trusts or sole trustee, non-directed trusts, but only have one trustee because he does not want any argument that because the trustee lives in some other state, that jurisdiction should be in that other state. So jurisdiction's a really big deal. I cited the Tingley case. This is a recent case from, I think, last year. It was an Illinois trust, Illinois asset, governing law, Illinois, principal place of administration, Illinois, but the corporate trustee was located in Indiana. And this was litigation brought in Indiana because that's where the corporate trustee was located, and there was a lot of fighting about that. The Indiana court held on to the case, and I think they ended up applying Illinois law, but they did hold the case. So that gets back into the conflict of laws issue. So this gets complicated very quickly. And then also on implementation, asset selection. I mentioned before, these should be assets that it's okay for the grantor to not use them. That's really important. It's good to have it be something that's going to grow in value. We've talked about personal residences and operating companies. LLCs, I don't even know how many of our trusts have LLCs, maybe the majority. So this is maybe the most common setup that we see is a DAPT that holds LLCs, and the LLCs hold other assets. So that's every day. Another decision factor on setting up the DAPT is how much of the client's wealth will be transferred to the DAPT. And there's no bright line rule. One key element is that the grantor has to retain enough assets outside of the DAPT to pay living expenses, debts, creditors, all of that, so that grantor is, first of all, remains solvent, and also really more than solvent, has enough. And ask 5 lawyers and you'll get 8 opinions as to what a good amount is. Personally, I'm on the conservative side. I think 25%, 30% would be my comfort zone, but I know attorneys who are fine with 50%. I know attorneys who are fine with more than 50%. It's a question of risk and the extent that the client is risk averse. And I'm not going to tell you how much is good and how much is bad. Only a court can do that. Selecting a trustee is really critical here. The administration of the DAPT is key. And again, back to that implied agreement. You don't want a fact pattern with an implied agreement. And so I'm a big fan of corporate trustees. I work for a corporate trustee. And one of the reasons is I'm very comfortable with corporate trustees. I've represented some fantastic individual trustees. There are individuals who are wonderful at being trustees, and they've done a phenomenal job. Trust them all the time. And then there are a lot of them who have great intentions, but they don't know what they're doing. They're busy, and this just becomes a headache for them. Most of my clients who have been individual trustees have wanted out, and a few of them have really liked what they do. Again, pick a trustee in a DAPT jurisdiction. Beware of co-trustees in other jurisdictions in case you have a jurisdictional fight. We've already talked about timing. You want to set this up when everything is calm and you're not anticipating divorce or bankruptcy or litigation. And unfortunately, that's not necessarily the time when people call and ask about DAPTs, but this is a big factor. Some states, Alaska is one of them, requires an affidavit of solvency when you create the DAPT. And I've actually used these for non-DAPs, just to make sure that the client, they're still making a transfer, make sure it's not fraudulent, and I have representation that they're not fraudulent. But the Alaska statute, what we require for an affidavit of solvency really is just saying, I have enough assets outside of this. I'm not defrauding creditors. This was not derived by unlawful means, and I'm not anticipating bankruptcy. So that's it. And then again, I will say it again, there cannot be any implied agreement between the trustee and the grantor, and that is upon setup. And this goes to talking with your client about expectations and making sure your client has realistic expectations of what this DAPT will do and will not do, and your client's ability to access the assets after creating the DAPT. We've talked about drafting, we've talked about setting it up, administration. A bad fact typically would be repeated distribution requests from the grantor that are honored. That would be a bad fact. Not saying the grantor can't make a distribution request. Absolutely, it's permissible. It just needs to be done cautiously. I've said a couple of times, involvement by the grantor, retained control. This can be a problem in the cases that we've been reading. It's how much involvement does that grantor have? The more involvement and the more control the grantor appears to have, the more the courts seem to want to do away with the trust and not grant the grantor any protections. And we've already talked about reimbursement for income taxes. This is the case I mentioned earlier when I said follow the statute. This CES 2007 trust case came out last year in Delaware. Really interesting case. That it was a Delaware DAPT that held LLC interests. The grantor was the manager. The LLC's owned real estate, and there were a lot of transactions between the grantor and the LLCs. He would put real estate in and out. He used one as a guarantee for loans. A lot of things between the grantor and the LLCs that frankly raise questions as to whether or not this should be honored. But the court, in a very brief opinion that to take you 5 minutes to read, and it's worth reading, basically said those issues were all at the LLC level. They were not at the trust level. They followed the rules on the trust. The trust was created in accordance with our statute. You are not piercing the trust. Period. End of story. The trust was upheld. The creditor was left to find other ways through. But this was an interesting case because they followed the statute for the trust. And the court said, we're not examining what's going on with the LLCs. We're only talking about the trust. So follow the statute. Be aware there are exception creditors depending on state law and what I call super creditors. The most common exception creditors are spouses for getting alimony, child support. There was a recent last year child support case in Alaska. The father had created a DAPT and he was investment advisor. I don't have the site here. I can always give it to you if you email me. But the long story short is the DAPT was upheld. It was a valid DAPT, and the assets, the court did not try to order that the assets be used to pay child support. But the court did award the mother more child support than the father wanted to pay. He just had to pay it out of other means. And it was an interesting case. I don't really agree with the result, but that's a story for another day. Property settlement upon divorce. We're going to talk about divorce in a minute. And then there's some other ones. Fraudulent transfers are a big one. Also be aware of statute limitations. It depends on the state. Dave Schaftel's chart is really great with that. Take a look. It's Alaska's 4 years. Some states are 2 years or less. So my tips for setting it up and implementation: know your state law. I've said that a number of times. Get a personal financial statement, which hopefully you all have estate planning questionnaires that ask for assets and liabilities, so you have that. I know an attorney who requires a credit report for any client creating not only a DAPT, but even a SLAP. So that's up to you. Open conversations with the client. Again, set expectations. That's really key, and no guarantees. Don't offer any. Okay, I've mentioned divorce. Aside from conflicts of laws, divorce is probably the hottest topic going on right now. Much with SLATs, but also with DAPTs, because a lot of clients are getting divorced, and divorce is very high. We have a high rate of it. So some things to think about. The way this is all at the planning stage. What we're seeing in cases is planning and implementation have a lot to do with the outcome on a divorce. But I mentioned earlier the definition of a spouse. This is selected at the drafting stage. If the spouse is a beneficiary, how is the spouse defined? And what happens upon divorce? Either the spouse remains a beneficiary after divorce, usually an unhappy result for the grantor, or the spouse's interest terminates upon the initiation of a divorce proceeding or dissolution of the marriage, or the interest terminates upon the dissolution of the marriage. Three very different results. What we observe at peak is as soon as the divorce starts, the spouse remembers that there's a trust in which the spouse is a beneficiary, and more importantly, the spouse's divorce lawyer remembers that there is a trust for which, or learns that there's a trust for which the spouse is a beneficiary, and makes a request for living expenses and for legal fees. And the legal fees are to fight the grantor, which gets into a question of grantor intent, because did the grantor intend to allow distributions for legal fees in an action against the grantor? And this gets very complicated and messy. So this is the time to think about this, is when you're drafting the trust. And there's a whole, there are a lot of presentations and articles being written about this right now. The other big thing that's happening, aside from the spousal definition, is the property that goes into the DAPT, marital property, and subject to division upon divorce. This is the Netter case. It's a recent case, bad facts case in 2025, and the husband, when quote unquote divorce was imminent, according to the opinion, created 3 DAPTs in South Dakota. He did it in secret. He was the sole beneficiary. Long story short is, it didn't go well for him. Huge judgment against the husband. And there were 2 cases that came out. I only cited one of them here. I think this is the one where the husband don't quote me, but may have mowed down the wife's vegetable garden. And that was, I think that turned the court off. In any event, control issues are really important. We've talked about that. The grantor may want to retain control. Just be very cautious about it. The other thing I'm seeing in divorces is the resolution. Because what we're seeing happening is these DAPTs, they'll terminate the trust, or the spouse will waive his or her interest in the trust, or some other resolution. Sometimes the kids will get involved. There are tax consequences to that. If you're terminating the DAPT, there are tax consequences: income tax, gift tax, estate tax, grantor trust issues. If your client is getting divorced and you're the estate planning attorney, try to stay involved, and because the divorce attorneys, they may or may not be well versed in what the impacts are of the tax impacts of a settlement. So try to stay involved so that you can keep an eye on it and warn them, hey, there are tax consequences to this that may be very unpleasant for the client and the client's family members. All right, bankruptcy. And I am not a bankruptcy lawyer, so please take that and keep that in mind. But what happens in bankruptcy with a DAPT? Well, the bankruptcy estate generally consists of everything that the debtor owns, but there is an exception, and I've got it cited here. If there's a trust and there's a restriction on the transfer of the grantor's interest that is enforceable under applicable non-bankruptcy law. That's the key. Enforceable under applicable non-bankruptcy law. I've got a case cited here where they talked about what that means. And this was in the context of a qualified plan under ERISA. But just a couple of examples. This Goff case, this is not a DAPT case. This is a charitable remainder trust case, but I thought it was just a good example, and I've got it cited here. It's fairly recent, and essentially the grantor created a charitable remainder trust, and the value of his unit trust interest was included in his bankruptcy estate. Alaska and some other statutes, we actually invoke this language in our statute that our spendthrift provision is enforceable, and it's under applicable non-bankruptcy law. So we actually go that effort. There are other states that do the same thing in our DAPT statute to make it clear, but be aware that there's a 10-year look back if there is an actual intent, if they can prove an actual intent to hinder a creditor. And this happened in the Mortensen case I have cited here in Alaska, where the grantor created the DAPT in 2005, transferred real property to it, and then declared bankruptcy 4 years later. And unfortunately, his trust expressly said that the express purpose of the trust was to maximize the protection against creditors of the grantor, and the court said, hey, you said it right in here. This is your intent. This is why you're creating the trust. They decided that was enough to prove actual intent to hinder, and they didn't void the trust. They said the trust was valid. They voided the transfer to the trust. So there's multiple ways creditors can try to erode DAPTs, not necessarily attacking the trust itself, but trying to avoid a transfer. And also caution, intent in the Mortensen case, it was established by the language in the document itself, but also just be aware, I see attorneys out there that advertise asset protection planning and they promise the world. I don't really care for that myself. I think that could that establish intent? And also remember, who's your client talking to, and what are they boasting? Are they emailing all their friends, or they're on Facebook saying, hey, I'm creating a trust and I'm going to avoid my creditors? These are discoverable communications, and could also go to intent. So in the last couple minutes, so hopefully I have not scared you away from DAPTs. I think they're really great planning tools if done correctly with the right people and the right facts. I think they're great. But there are some alternatives if you are not as comfortable with a full-on DAPT. Hybrid DAPTs, there's really no exact definition, but it's DAPT-ish, where usually what it means is that either the grantor is not a beneficiary at the outset. Usually it means the grantor is not a beneficiary at the outset. Can either be added as a beneficiary, which I have seen, or maybe the grantor becomes a beneficiary after a period of time, or some combination thereof. But it's a hybrid DAPT, so that gets people a little more comfortable. SLATs, spousal lifetime assets trusts, have been used like M&Ms in the last, 5-10 years, and they're great. And we sold them as, saying to our clients, as long as you're nice to your spouse, you'll get the indirect benefit of the assets. The problem is they're getting divorced now, and that's not the case, and we're finding some nasty consequences to SLATs. So there's still good planning, there's still good alternatives, but like everything, there are risks with it. So just be aware of that. And then lastly, the special power of appointment trust, which we call a SPAT. So we've got DAPTs, hybrid DAPTs, SLATs, and SPATs. And a special power of appointment trust is an irrevocable trust for others. But the key is that the grantor gives another individual the non-fiduciary lifetime power to appoint the assets to a class that consists or that includes the grantor. So the most common one is, I create a trust, an irrevocable trust for my son. I give Peak Trust, who's not related to me, the power to appoint the assets in the trust to the descendants, one or more of the descendants of my maternal grandparents. So that includes me. Now, the risks there, first of all, it's a grantor trust by default. And secondly so I have to pay the income tax. There's no guarantee that Peak Trust is going to exercise that power if and when I need it. And that's a risk. Or Peak could exercise it, and if I defined my class in this example as the maternal or the descendants of my maternal grandparents, Peak could turn around and give the assets to a cousin or a sibling. So that's that may not work out well for me either. So there's still risk even at that, and divorce is always going to create a risk. And so but it is an alternative. So just some key takeaways. We're at the top of the hour. I think DAPTs are good. I think they're good tools. But with that said, the right people, the right assets, the right drafting, the right implementation, the right administration, it all has to be done well. And it requires care and feeding. This is what I try to explain to people. Tell your clients, these trusts require care and feeding. You don't set it and forget it. There's stuff that has to be done. State laws vary. You really need to be aware of the states. All the states that may touch this trust. The client needs to be a good fit. And we always say bad facts make bad law. Facts make or break it. Okay, thank you for the opportunity. And everyone here is welcome to reach out to me with questions, or if you just want to chat about the jurisdiction or DAPTs in general.
All right. Thank you so much, Abby, for that presentation. Really appreciate it. And thank you guys all for joining today. Just wanted to mention really quickly before we close up here, as a follow-up resource, we did include the comparison chart in the resource area of the Zoom event that Abby mentioned, the one put together by Dave Shaftel for AgTech, comparing domestic asset protection jurisdictions. So make sure to download that as well as the slides, and feel free, of course, to reach out to anyone here at Peak Trust Company. Abby's information is in the slide deck and on our website, or you can reach out to anyone at Peak Trust Company if there's any follow-up after this presentation. But once again, thank you all for coming, and have a great rest of your day.